Imagine if a single stroke of a presidential pen could reshape the constitutional landscape of America, restoring reproductive rights and ensuring equality for women. Now, imagine that this change has been a century in the making, passed by Congress over 50 years ago, and only awaits formal recognition to become the law of the land. This is not a hypothetical scenario. It is the real and pressing debate surrounding the Equal Rights Amendment, ERA. With President Joe Biden's administration nearing its final stages, a bold opportunity has emerged to cement the ERA as the 28th Amendment to the United States Constitution. But what's the catch? Why has this seemingly straightforward action stirred so much controversy and resistance? In today's deep dive, we unravel the historic context, legal implications, and potential future of this landmark amendment that could define Biden's presidency and forever alter the political chessboard for figures like Donald Trump. The long journey of the Equal Rights Amendment. The Equal Rights Amendment has been a century in the making. Originally proposed in 1923, it sought to enshrine gender equality into the Constitution, declaring that equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. However, decades passed before Congress finally approved the amendment in 1972, sending it to the states for ratification. According to constitutional rules, an amendment must be ratified by 3/4 or 38 of the states to become law. At the time, Congress included a deadline of 10 years for states to ratify the amendment. By 1982, the ERA had fallen 3 states short of the required number. Proponents of the ERA faced a grim reality. The amendment's progress seemed stalled indefinitely. Yet, the story didn't end there. Over the decades, grassroots activism and political shifts reignited interest in the ERA. By 2020, Virginia became the 38th state to ratify the amendment, fulfilling the constitutional requirement. But there was a catch. The original deadline had long expired, leading to heated debates over whether the amendment could still be valid. The story of the ERA is not just one of delays, but also of resilience. Generations of women, advocacy groups, and progressive leaders have kept the fight alive. Organizations like the National Organization for Women, NOW, and prominent figures like Gloria Steinem champion the ERA as a vital step toward true equality. These efforts have ensured that the amendment remains a topic of national discourse, even as its legal status remains contested. Legal arguments and constitutional timelines. One of the most contentious issues surrounding the ERA is the validity of its timeline. Opponents argue that the expired deadline renders the amendment void. However, constitutional scholars have pointed out a critical detail. The Constitution itself does not mandate a time limit for ratification. This argument gained traction in light of the 27th Amendment, which regulates congressional pay. Proposed in 1789, it was ratified over 200 years later in 1992, proof that amendments can endure prolonged timelines without losing their validity. Proponents of the ERA argue that the 1972 deadline was an arbitrary constraint imposed by Congress, not a constitutional requirement. Furthermore, they contend that once a state ratifies an amendment, it cannot rescind its approval. This principle, often summarized as no backsies, ensures that states' initial decisions are binding and irreversible. Applying this logic, Virginia's ratification in 2020 completed the ERA's journey, making it eligible for formal recognition. Adding to the complexity, some states have attempted to rescind their ratification of the ERA. States like Nebraska and Tennessee argue that their current legislatures have the right to overturn decisions made decades ago. However, legal experts widely agree that the Constitution provides no mechanism for rescinding ratifications. This legal gray area has fueled lawsuits and debates, setting the stage for a possible Supreme Court showdown. President Biden's role and the National Archivist. This brings us to the present moment and President Joe Biden's pivotal role. As the head of the executive branch, Biden has the authority to direct the National Archivist to publish the ERA as the 28th Amendment. Such a move would signify the federal government's formal recognition of the amendment, effectively enshrining it into the Constitution. During a recent interview, Biden expressed his support for women's rights and hinted at the possibility of taking action on the ERA. This has renewed hope among advocates, including Senator Kirsten Gillibrand, who has championed the ERA for years. Gillibrand has explored multiple avenues to advance the amendment, including legislative resolutions to affirm its ratification. However, with Congress deeply polarized and the Senate 60-vote threshold proving insurmountable, the focus has shifted to executive action. The role of the National Archivist is critical in this process. As the official responsible for certifying amendments, the archivist's decision to publish the ERA would carry immense legal weight. In 2020, then National Archivist David Ferriero declined to publish the amendment, citing the expired deadline as a barrier. Now, under the Biden administration, a new archivist could reverse this decision, paving the way for the ERA's official recognition. The potential impact of the ERA. If President Biden orders the National Archivist to publish the ERA, the implications would be monumental. First and foremost, the ERA would provide a robust constitutional foundation for gender equality, empowering women to challenge discriminatory laws and policies. In a post-Roe v. Wade era, the amendment could serve as a crucial tool for safeguarding reproductive rights, ensuring that laws restricting bodily autonomy face heightened constitutional scrutiny. Moreover, the ERA's passage would send a powerful message about America's commitment to equality. It would place gender rights on equal footing with other fundamental protections, such as freedom of speech and the right to vote. For a nation grappling with deep divisions over social justice and identity politics, the ERA could serve as a unifying milestone, reaffirming the principles of fairness and inclusion. The ERA could also have far-reaching implications for workplace policies, family law, and LGBTQ+ rights. By prohibiting discrimination on the basis of sex, the amendment could strengthen protections against sexual harassment, close wage gaps, and challenge laws that disproportionately affect marginalized groups. These changes would not only benefit women but also foster a more equitable society for all Americans. Political and legal challenges. Despite its transformative potential, the ERA faces significant challenges. Conservative lawmakers and advocacy groups have vowed to oppose any attempt to recognize the amendment, arguing that it could lead to unintended consequences, such as expanded protections for LGBTQ+ individuals or the invalidation of sex-based distinctions in certain laws. Some states that initially ratified the ERA have even attempted to rescind their support, further complicating the legal landscape. Additionally, any executive action by Biden would likely face immediate legal challenges, potentially delaying the amendment's implementation. Critics might argue that bypassing Congress undermines the legislative process, setting a controversial precedent for future administrations. The judicial branch will also play a crucial role in determining the ERA's fate. Legal challenges to the amendment's validity are likely to reach the Supreme Court, where the justices' interpretation of constitutional law will be decisive. With a conservative majority on the bench, the outcome remains uncertain, adding another layer of complexity to an already contentious issue. The Trump factor. Recognizing the ERA as the 28th Amendment would also have strategic political implications, particularly in countering the influence of Donald Trump and the broader MAGA movement. By championing gender equality, Biden could solidify his legacy as a progressive leader while drawing a sharp contrast with Trump's track record on women's rights and social justice. This move could energize Democratic voters and galvanize support among key demographics, including women and young voters, ahead of future elections. Trump and his allies have consistently opposed policies that promote gender equality, framing them as threats to traditional values. By advancing the ERA, Biden could undermine this narrative, positioning himself as a defender of modern American ideals. This strategy could prove particularly effective in swing states, where suburban women and independent voters hold significant sway. The broader context of women's rights. The ERA is not just about constitutional text. It represents a broader struggle for women's rights in America. From the fight for suffrage in the early 20th century to the #MeToo movement of today, the push for gender equality has been a defining feature of American history. The ERA's ratification would be a culmination of these efforts, marking a new chapter in the ongoing quest for justice. At the same time, the ERA's passage would highlight the limitations of existing legal frameworks. While laws like Title IX and the Equal Pay Act have made significant strides, they lack the constitutional permanence of an amendment. By enshrining gender equality into the Constitution, the ERA would provide a stronger foundation for future reforms, ensuring that progress cannot be easily rolled back. The Equal Rights Amendment represents more than just a legal or political issue. It is a moral imperative that speaks to the core values of equality and justice. With Virginia's ratification fulfilling the constitutional requirement, the ERA stands on the brink of becoming the 28th Amendment. President Biden has a historic opportunity to cement this legacy, restoring reproductive rights and advancing gender equality for generations to come. However, the path forward is fraught with challenges, from legal battles to political resistance. The stakes are high, and the clock is ticking. As the Biden administration considers its next steps, one thing is clear. The ERA's time has come, and the fight for equality is far from over.